I'm Carlos Haro. I'm coordinator of the Education Summit, the Latina Education Summit. This is the 8th annual summit, the 8th one. And last year, we had an education summit that was co-sponsored by the UCLA Law School, and Dean Rachel Moran was a co-sponsor, along with MALDEF and Mexican American Education, Legal Defense and Education Fund. MALDEF was a co-sponsor of that conference, and we had Tom Sines here and the Dean here all day long. That conference, Law and Policy, Conversations Across Disciplines, assessed the impact of litigation and legislation on Latino education, and it was fairly broad. This year, in conjunction with the law school and Dean Moran, we will specifically address a U.S. Supreme Court ruling dealing with affirmative action and diversity at the university level. The case, Fisher versus the University of Texas, will be discussed throughout the afternoon by faculty from the law school, faculty from the Graduate School of Education and Information Studies, and faculty from Chicano and Chicano Studies, with presentations also from university specialists in student affairs and admissions. I want to thank all of our presenters today for taking a critical look at an area of continuing concern for Chicanos and Chicanas in higher education, and an area of education that affects all students of color. We also had graduate student participation in this conference. The policy brief and the research report that are companion pieces to this conference were at your seats. And they should be read. They give you excellent background reading material on the Fisher case. The material was co-authored by Marcia V. Fuentes, a doctoral candidate in the Graduate School of Education and Information Studies. The research report and the policy brief that you have available for you were both co-authored by Marcia. In addition, there is a note in the program that you have that was co-authored by Jacqueline Caraves and Liana Hidalgo. We have a group, there's a posse over here of PhD students from the graduate program in Chicano and Chicano Studies. Raise your hands down there. Okay, that's our, that would be our first cohort of PhD students in Chicano and Chicano Studies at UCLA. Our first cohort. And now this year the format for the summit is different. It's contained in this room. We're having lunch in this room. We're going to have the keynote address in this room, and we're going to have the panel presentations in this room. And it's, the afternoon is dedicated to one thing, to looking at the Fisher case and its ruling. So at the very end, we'll have a closing session where Dean Rachel Moran and Director Chon Noriega will help us sum up what's occurred during the afternoon. And now I'm supposed to introduce the director of the Chicano Studies Research Center, but I'm not quite sure how to introduce him. He wears so many hats. So many hats. He's a professor of film, television, and digital media, director of the Chicano and Chicano Studies Research Center, and adjunct curator of Chicano and Latino art at the Los Angeles County Museum of Art, LACMA. He has distinguished himself as a scholar at UCLA, but again, what sets him apart is the direct impact he is having outside of academia in the arts, media access, archival development, and education. For the past 11 years, he has been director of the Research Center, a unique and comprehensive institution that was founded in 1969. 1969, a very important year for the Chicano movement. In 69, the center was established as the Mexican American Cultural Center, which became the Chicano Studies Center, which became the Chicano Studies Research Center. Although the name changed during the course of those years, a number of decades, the emphasis has always continued to be the same, a focus on the Mexican American Chicano community. With his involvement, the Chicano Studies Research Center Archive and Library, this library is the only such library that focuses on the Chicano community in the UC system. And it may be the only such entity at the university level in the United States. The Chicano Studies Research Center Library now has, for example, a holding of 50,000 Spanish language recordings covering the first half of the 20th century. And you can go online here at our library and access those songs, 50,000. One major coup that Professor Noriega had several years ago was receiving the Edward R. Roybal collection and bringing it to UCLA. That was in 2010. That's a massive collection on Edward Roybal's life and times. Huh? A significant collection for any university, but it's coming to this university, and it's here at the Chicano Studies Research Center collection. A recent achievement was the center being named to receive the Sal Castro collection. Any of you that know about Chicano education know the name Sal Castro. The Sal Castro collection is coming to UCLA. Sal passed on April the 15th of this year, and we will have an event at the Research Center on October the 15th dedicated to Sal Castro's memory and legacy, and the continuing research that can be done on Sal Castro in the Chicano Youth Leadership Conference can be done here at this campus. Now, through the Chicano Studies Research Center Press, Noriega has been, I continue to speak about, he's not looking this way, but I continue to speak about you. Professor Noriega has been the editor and publisher of the Center Press since 1996. Now, that press produces Aslan, a journal of Chicano studies. Right? It is the journal in the field, the journal in the field. He's also produced a number of book series and a DVD series of recovered and restored early films, one award-winning series, and all of you should have these books, A Ver, Revisioning Art History. It's the first to document the life and the works of individual Latino and Latina artists. That hasn't been done before. The projects that Chon Noriega has been involved with fall outside of academia as well. In 2008, he organized and co-curated the first Chicano art exhibit at LACMA in 33 years. It took 33 years to have a Chicano art exhibit at LACMA. He facilitated a concurrent installation of Marin's exhibit at LACMA as well. So there were two Chicano exhibits at LACMA at the same time. Unheard of. But this happened because Chon Noriega worked at it and made it happen. There was also an exhibit here at UCLA at the Fowler Museum. And I was very proud to be among the very large number of people trying to get into the Fowler Museum to see a Chicano art exhibit. And that occurred in the year, what was it, 2010 maybe? No, 2011. That was Mapping Another LA, the Chicano art movement. Now that broke records here at the Fowler Museum. Now what's notable about Professor Noriega's contributions is that he's not only a bridge for academia and the community, He also works in other areas. He's a television personality. Television personality. All of us here should have seen the Turner Classic Movies series on race and Hollywood, Latino images in film. We should all have seen it. 40 films that Chon selected and were shown on Turner Classic Movies. And you can just imagine Chon Noriega talking to Robert Osborne and this broad audience, national audience, cable audience about Latinos in films. All right, that happened. That happened. Now, I have no idea where Chon Noriega finds the time to do all that he does. I have no idea how he does that, but he does it. He does it. And he certainly is a visionary, and he certainly makes a difference. He is one of the most important faculty here at UCLA. And I'm very proud of what he has done at the Chicano Studies Research Center. He has made it an invaluable instrument for change. All right. Chon, did I embarrass you enough?
Sure.
Okay.
Well, that didn't help. Let me see. Give you that nice pleasant orange to look at. Well, thank you, Carlos. And given that that was the introduction just for the person who's going to give welcome, you can see what we're in for today. I've set aside about 40 minutes for my introduction of Rachel Moran. And we'll go from there. Thank you, Carlos. He mentioned that I wore many hats, and I was tempted to bring the hat I did wear today up here. Instead, I'll just note that since my former staff, they've all been fired, spelled my name wrong, that instead of a name, what you're going to see is a smiley face emoticon. That's me. I figured I was the person that hired them all, but somehow they got the E and the I mixed up. Made me into a Portuguese descent person. I want to thank you all for coming to this, which is our 8th annual Latino Education Summit, especially when you woke up today and you looked at the weather and saw it was going to be 87 degrees at UCLA and in the 90s elsewhere, and still you did not head to the beach. So I think it's a tribute to your commitment to education, your interest in being part of the dialogue we'll have throughout the day, that you are here with us. As Carlos mentioned, this is a different setup. We'll remain seated in this way. Those of you that are on the inside loop will be able to turn your chairs. But the idea is to keep this as conversational as a panel can be, and also to keep it focused around two discussions so that we can really dig deeper around the days ahead, as it were. We're fortunate to have our former and hopefully returned colleague Chris Gutierrez here, and that is a tribute to the United States government. Because they selected to be shut today, she was able to join us. And that says something about what we're talking about here in terms of the role of law in education. We have, over previous years, looked very closely at aspects of education in terms of its functionality, but also its impact. And by all measures, if you are trying to address a significant social issue in our society, education is going to be part of the answer. And in most cases, it's going to be the front line in the answer. Now, we realize that law is a significant aspect of that, and particularly in this current moment, where if you do not like the current laws, you have, as a major recourse, the ability to simply shut down the government. That is the current regime we're in. You realize that the reason that the government is shut down, and the reason that we're going to continue to have issues that are going to be a direct impact to our economy and to our educational system, is because some people, a fairly small minority, do not like the law. And this is the recourse that they see available to them. Now, nowhere in the course of all of this have we mentioned one particular law, which has to do with sedition, but that is for other people to discuss. I think that we're going to take the other approach here. And that is the constructive dialogue about the nature of law as an evolving institution. And in particular, to look at the recent Fisher versus Texas decision, not as an endpoint, but as another step in that dialogue, and to see to what extent we can identify what are the issues that remain to be explored, and what are the contributions that we can make as people who are directly invested in education in terms of where the legal framework for education goes over the next decade. They're bringing out the lunch, and I'm going to allow you to eat that without the disturbing sound of me droning on for that. So I'd like to end just by thanking our partner, the School of Law, and Dean Rachel Moran, the speakers who will be here throughout the day, taking part in the discussion, Cheryl Harris, the spirit of Devon Carvado, Robert Chao Romero, Silvia Hurtado, Janina Montero, Yolanda Copeland Morgan, and Susan Wilbur. And at the end of the day, Rachel and I will give a brief encapsulation of kind of where we get to, because that's part of the goal of this conference. It's not to come here with the answer, but to explore the questions and see where we need to go next. And you should all know that, as with all previous education summits, what we discuss here, where we end up at the end of the day, and what you are recommending to us will set the framework for our next education summit. And we'll begin the process starting on Monday of beginning to lay the foundation, the research that's necessary to bring us to that point. So I want to welcome you. I want to thank you again for your commitment. I'll end with one note. As I do, Carlos said a lot about my activities and about the center. He hit upon something that I think is absolutely crucial, and it's a cornerstone of higher education, and that is the role of the library and the archive. And we take that very seriously. We do have the largest archival holdings in the country, and by default in the world. We were looking at the impact of these collections. If the Chicano Studies Research Center archival collections were not here, UCLA would go from being the first in the state and the nation to being fourth, behind several California State University holdings. We're pivotal both in this institution and in the field nationally. Law and education are significant cornerstones of that, because together they have driven social change over the last 40 years. In addition to the collections that Carlos mentioned, we were the first to get and make publicly accessible the Sheriff Department investigations into the death of Ruben Salazar. Those are going to be available universally online, but we were the first outside of a handful of journalists that would have mediated access to those documents. We also brought in earlier this year the La Raza magazine and newspaper photograph collection. Now, the significance of that is that magazine and the photographers associated with it produced a lot of the visual evidence that showed that the moratorium against the Vietnam War was in fact a police riot. And the 20,000 negatives that have been associated with that collection have been inaccessible over the last 40 years. We are now in the process of digitizing them, and they'll be available again online starting later this year. So we encourage you to use that resource. It's there for everyone. We make no distinction between those affiliated with the university and those who simply want to know more about the history, the contributions, and the issues facing our population here. And by that I mean the nation, with Chicanos and Latinos as a significant and growing part of it. So thank you. We're looking forward to your participation, not just your viewing of this event. And I'll be introducing the dean. My watch isn't working, but after you've had a chance to eat. Thank you.
Well, first of all, I wanted to thank Chon and Carlos for all the work that they did, as well as the staff who have put this event together. We're delighted to be co-sponsoring the summit again this year. And I also wanted to thank all of you for being here on a Friday afternoon to think hard about the future of diversity in higher education. Now, Fisher versus Texas, recently decided, was a case that was awaited with great anticipation. And you may remember that before the case came down, people thought it was going to be a very close decision, probably 5-4, that Justice Kennedy would be the decisive vote, and many people expressed concern that Fisher would essentially call to a close affirmative action in higher education. As it turns out, none of those things was really completely true. First of all, the court did not put an end to affirmative action, as we'll see as we go through the case. Also, it was a 7-1 decision, which surprised a lot of people. Only Justice Ginsburg dissented, and Justice Kagan had recused herself because of work that she had done previously in government. Now, that said, the case did leave a lot of ambiguity. Far from being a decisive statement about the future of affirmative action, the court left open many, many questions, and that's really what draws us here today. So what I wanted to do in this keynote, knowing that you'll have a rich array of panelists later this afternoon, is just to give you some background about the legal developments leading up to the case, to highlight some key features of the Fisher decision, and then to kind of walk you through a few of the unanswered questions. I have the unusual opportunity later today to comment again, and so I won't spend a lot of time belaboring conclusions, but I'll defer some of that to the final closing remarks. Now, the first thing that I wanted to do historically was situate Fisher, because many people forget that before Brown versus Board of Education called to a close de jure segregation in the public K-12 system, the National Association for the Advancement of Colored People targeted institutions of higher education. They believed that they could make a good case against de jure segregation in state colleges and universities because it was impossible to make these complex, highly supported institutions separate and equal as an empirical matter. And so they went through a whole series of decisions, and ultimately, interestingly, in Sweat versus Painter, which was a challenge to the University of Texas Law School's de jure segregation in admissions, they found that not only could the schools not be made equal in terms of tangible things like the faculty and the quality of the facilities and the breadth of the curriculum, but also in terms of intangible things like the alumni network and the connections and social capital you would develop by being an alumnus of the UT Austin Law School. Now, what these early pre-Brown versus Board of Education cases did was to eliminate formal barriers to access. That is to say, you could no longer have a policy that blacks could not apply for admission. But without support for that access, the numbers of underrepresented minorities remained very low in our colleges and universities. Now, what happened in the 1960s and 1970s is there was a period of tremendous civil unrest around questions of race and equality. And as a result, not through the court's action, but through executive policy and congressional affirmation, affirmative action developed. And it came to colleges and universities around the country. Now, by the 1970s, in the late 1970s, there was a growing concern, particularly as we saw some economic challenges in the country, concerns about displacement from colleges and universities. And so the first very prominent legal challenge comes in Bakke versus Regents of the University of California, a case decided in 1978. And Bakke was interesting because it was also a 4-1-4 decision. 4 justices basically said that you should be completely colorblind in admissions and race should not be used in any way. Another 4 said that race should be available broadly to rectify the lack of representation. And the swing vote was Justice Lewis Powell. And Justice Powell essentially sort of carved a path through the middle and said, yes, we can consider race, but we can only consider it for very narrow purposes. The purpose of advancing the exchange of ideas, diversity, understood as a robust dialogue in which people brought their different experiences to the table, Ruled out as a compelling purpose were rectifying general societal discrimination or creating greater parity in the professions, in this case the medical profession. So the court said we're going to strictly scrutinize these programs, but you can invoke diversity as a compelling interest. You have to use a narrowly tailored means of achieving that interest, and the court said you have to have individualized review. The University of California, Davis had set aside some seats for people from underrepresented groups. The court said that's impermissible. Justice Powell said you have to compete with everyone in the applicant pool, and when you do, race can be a plus in evaluating your application, but there cannot be quotas or set-asides. After Bakke, the level of representation of people of color in colleges and universities, particularly underrepresented groups, remained about the same. And there was actually very little research done after Bakke on the benefits of diversity to the educational process, even though Justice Powell had signaled that that was the one justification that was constitutionally available. Now, by 1996, there was a very significant challenge to affirmative action back to Texas. We talked about Sweat versus Painter, but in Hopwood versus Texas. And in 1996, the Fifth Circuit concluded that the only basis for considering race in admissions would be to remedy a history of past discrimination at the University of Texas. And if you had remedied any past discrimination, there was no place for voluntary affirmative action done without any proof of past institutional wrongdoing. Now, in the wake of Hopwood, the Texas legislature actually put together something called the 10% plan, which allowed the top 10% of students from Texas high schools to be granted admission to the University of Texas at Austin. This was promoted by a very interesting coalition. So Irma Rangel clearly was trying to promote better access for underrepresented groups, but there were schools in small rural communities in Texas that had never sent a graduate to UT Austin. And so this coalition of sort of rural community representatives and representatives of districts predominantly people of color together were able to get this through. And it had some dramatic results, and I'll come back to that in a minute. Meanwhile, in the state of California, at about the same time, the courts had not struck down what was going on in California, but the people of California went to the polls and adopted Proposition 209, which eliminated the use of race or ethnicity in any kind of government decision-making, including admissions to the state's public colleges and universities. We were not alone in seeing that kind of policy adopted, but I think we stood out because California is the most diverse probably state in the nation, and it also had some of the most elite public colleges and universities. So it was a very, very important place to get started if you wanted to try to close down affirmative action by popular referendum. Now, in 2003, everyone was once again worried because the court had granted certiorari in Grutter versus Bollinger and Gratz versus Bollinger. And these were companion cases that went to the Supreme Court challenging affirmative action at the University of Michigan, both in the undergraduate program, the Gratz case, and the law school, the Grutter case. Now, people once again were worried that this would be a close decision and that it might bring Bakke to an end, that there would be no more space for affirmative action in higher education, at least at public colleges and universities. Now, what happened in Grutter was, yes, it was a close case. It was 5-4. The really decisive vote here was Justice Sandra Day O'Connor, but I think she actually strengthened Bakke in her opinion, because she said that diversity is a compelling interest, but she went further in the law school case and she said that elite law schools are the pathway to civic leadership in America, and we will not have democratic legitimacy if people from all walks of life are not represented in those universities, in those law schools. And so she actually added another rationale. Beyond the internal robust exchange of ideas represented by diversity in Lewis Powell's opinion, she added an external looking approach, which looked at leadership after you graduate and said that also matters, civic leadership. That also meant that certain briefs were much more influential. Amicus briefs from leaders of Fortune 500 companies and from military generals about the impact of diversity in business and our defense. So as she affirmed diversity as a compelling interest, she did a couple of other very important things. First, she said that race-neutral alternatives need not all be exhausted in order to use race in admissions. So she, for example, rejected the use of a lottery for admissions because it would undermine the elite status of the University of Michigan Law School. She also embraced and reinforced the need for holistic review, but she also said that universities could try to achieve something called critical mass, that there had to be a level of representation that allowed the goals of affirmative action to be achieved. If you had a very isolated group of underrepresented students, they might not feel free to express their opinions precisely because their representation was token in nature. And if that happened, it would undermine the very goal of diversity, the exchange of ideas that lies at the heart of the rationale for these admissions policies. But she did add that she hoped that in 25 years, we would no longer need these programs. Now, one of the responses to the Grutter case was that the electorate of the state of Michigan went to the polls and adopted a proposition very similar to that in California. So they essentially overturned Grutter at the ballot box. Again, after Grutter, we see universities pretty much staying the course, not making dramatic changes, but also not doing the diversity research that needs to be done to uphold these programs and show that their justifications are being advanced. And that's why we're so happy at the law school to partner today, because I know many of you are doing the kind of social science research that we need in order for lawyers to go into court and defend these programs. I will say lawyers depend very heavily on experts, and I'm so pleased to have the graduate students and recent graduates here who are going to be the leaders and the experts who will be participating in these cases. Now I'm going to digress for just a moment from the area of higher education and talk about a school desegregation case that took place in the K through 12 level, and that's parents involved in community schools, which was decided in 2007, also a 5-4 decision. And I want to highlight this case because in the past, if you looked at school desegregation cases in K through 12, they were largely running on a parallel track from the higher education affirmative action cases. The jurisprudence really seemed to be quite distinct. And in the parents involved case, Justice Roberts wrote that higher education was just going to be compartmentalized, that Grutter was different because it involved academic freedom and deference to higher education administrators, a deference that was not necessarily appropriate when dealing with K through 12 education. Now, this case was interesting because there were two 5-4 parts of this decision. There was the 5-4 group that basically said, yes, you can continue to consider race in school desegregation that's done voluntarily. You can consider diversity. You can consider avoiding racial isolation. And you can consider the need to counter racial stereotypes, as well as rectifying past acts of egregious discrimination. But there was another 5-4 alignment that basically said you cannot use race in the individualized assignment of students. And so you can value race as a goal, right? Racial diversity as a goal, but when you're assigning individual students to schools, you can't use that. And you can't even use it in a very minor way, because in one of these districts, they had many, many factors that factored into your school assignment, and race was just a tiebreaker. And that was struck down. So the way that you could consider race according to the 5-4 majority on this point, the implementation, was through things like structural decisions about where to place a school or where to draw school boundaries, things that did not involve differential treatment of individual students with respect to their assignments. Now, I'll come back in a moment to why I think that parents involved case is important when we think about Fisher. But here I want to turn to Fisher, and I want to give you a little bit of background about the case, because I think it's important to know some of these details, not all of which appear, by the way, in the Supreme Court's opinion. Some of them are in the lower court decisions. Now, the University of Texas, like the other public schools challenged, is a highly selective institution. Affirmative action is not as relevant to schools that aren't highly selective. So these elite schools have been the target, schools like Texas, Michigan, the University of California. The University of Texas, in the year that Abigail Fisher applied, got about 30,000 applications for 6,715 spots in the class. Abigail Fisher had a GPA of 3.59, and her SAT was 1180 out of 1,600. Now, the first problem that Abigail Fisher had was that she was not in the top 10% of her high school in Sugar Land, Texas. And once you're not in the top 10% of your high school in Texas, if you are a Texas resident, your odds of being admitted fall precipitously, because for Texas residents, of those residents, 88% of the offers made are based on the top 10% plan. 81% of the class is based on the top 10% plan. And for Texas residents, 92% of those slots reserved for Texas residents are filled through the top 10% plan. So if you don't make it through the top 10% plan, you will be competing with many, many people for a tiny number of spots. Only 841 Texas residents are admitted to UT through something other than the 10% plan. So remember, 30,000 people applied, so there's thousands and thousands of Texas residents, those are mostly Texas residents, out there competing for these 841 spots. Now, how are those 841 spots allocated? Well, the University of Texas at Austin, after Hopwood, used a race-neutral process of looking at your academic credentials and something called the Personal Achievement Index. Now, after Grutter, the University of Texas Austin went back and said, we will continue to look at your academic credentials, but we will add race as one factor in your Personal Achievement Index. Important things to note: race was not given a numerical weight. It was just a factor. Also, whites were eligible to improve their Personal Achievement Index using race in the process. So if white students had done volunteer work in Latino communities, this would be relevant to their Personal Achievement Index. So it's very useful to note that, because sometimes people assume that race was reified in the process, or it was given a numerical weight, or certain people were excluded from getting a benefit, but that is actually not the case. Now, what's interesting is that if you look at that process, as I said, it generates very few, and if you don't get in through that process, there's one more way to get in. You can get in through a summer or coordinated admissions process. And so under the summer program, a very small number of people go to summer program, and if they do well enough, they get to go to UT after the summer program. The others are offered the chance to go to another partner UT system campus. And if after the first year they take 30 credits and they have a GPA of 3.2 or higher, they are guaranteed automatic transfer to the University of Texas Austin. So Abigail Fisher was actually offered the coordinated system opportunity, but she did not take it. She went to the Louisiana State University instead, and so she wasn't able to benefit from that possibility of going to UT Austin. Now, I give you this background because I think it's important in understanding some of the legal issues. The first question was, did Abigail Fisher actually have standing to challenge her denial of admission? Under the Constitution, the court doesn't take just any case. You have to show some kind of actual individualized injury. And Abigail Fisher could not, I think, plausibly argue that she would have been admitted in the absence of race being a very lightly weighed factor in the evaluation of her personal achievement index, because there was testimony that because her GPA was what I had indicated, 3.59, she was about 12% in her class, and her SAT was below the typical average of an entering student at UT Austin, even if she had had a perfect score on the personal achievement index, she would likely not have been admitted because of her academic credentials. So her attorneys actually framed the question differently. They said it's not right to ask whether she would have gotten in absent the weighing of race in the personal achievement index. Rather, what we ought to do is compare her profile to that of blacks and Latinos who got in under that system. And the court rejected this. And I want to tell you why I think that was correct. I think it's correct because Bakke told us, and the court has never retreated from the fact that you have to compete with everybody in the pool using an individualized assessment, and to segregate out for the purpose of standing this subgroup of students and say those are the only people you compete with in admissions seems to me to be a disservice to the court's understanding of how the admissions process should work. Now that said, what the court did was to actually adopt an extraordinarily broad view of standing because it redefined the injury. The injury is not being displaced from admission. The injury is being exposed to a process which you believe is racially unfair. So that means that any applicant to the University of Texas who doesn't get in, whether marginally competitive or completely uncompetitive, can sue the university and get into the courthouse doors. So the first thing to note here is the courthouse doors are wide open, right? There's a very broad notion of standing. Now, another issue that came up was whether this case was moot. Abigail Fisher went to Louisiana State University. She got her degree. I think she's actually back in Austin working right now. And she says, I regret, that I didn't get in now because I could have probably made a higher wage and I'd have had better connections. But she did get her bachelor's. And so this issue it's really interesting. It was raised at the time this went up to the Supreme Court. It really was not engaged. The only person interested in jurisdictional issues on the court seemed to be Justice Sotomayor. But now that the case is on remand and it's back at the lower courts, this issue is being argued again. And we don't know yet what's going to happen on that front. Now, on the merits, I think it's very important, although people worried that this case would overturn Grutter and end affirmative action, if you go back and read the briefs, the parties never challenged the fact that diversity is a compelling interest. So they accepted that. But they said that it wasn't compelling enough to justify what the University of Texas at Austin was doing. So this case became all about narrow tailoring. And the first question that comes up is, did the University of Texas at Austin really need to rely on race at all because of the success it had in diversifying the student body just with the 10% plan alone? So if you look at the statistics that the court focuses on, it focuses on the fact that before Hopwood, when the UT Austin used conventional forms of affirmative action, there were 4.1% African Americans in the student body, 14.5% Latinos. And that after Hopwood, using the race-neutral system that I mentioned, the top 10% plan and the personal achievement index without race, they had 4.5% African Americans in the entering class, which was higher, and 16.9% Latino, which is also higher. Now, so one question that's going to come up on remand is, do you really need race at all? And I think this will be interesting because we know that this race factor plays a very limited role in diversifying the student body. It's very much at the margin. And if you'll remember my mention of the school desegregation cases, there too, race was like a tiebreaker at the very margin, and the court said that's too much. So as we see the school desegregation at K through 12 and higher ed beginning to converge, one of the features is to take a system where race matters very, very little and say that's still too much. Now, the other interesting thing is whether there was critical mass. And this has been a big dilemma, because if you put a quantitative figure on critical mass, you will be accused of having a quota. And if you don't, everybody says, well, how can we measure whether you achieve critical mass, right? So what the University of Texas did is dance around a little bit on this one. But what they said is, whatever our aggregate numbers, we do not have critical mass in terms of achieving our pedagogical goals, because when we look at the distribution of students among classrooms, with 10 to 24 students, 90% of those classes will have 0 to 1 African Americans, 46% of them will have 0 to 1 Asian Americans, and 43% will have 0 to 1 Latinos. And therefore, we are not achieving the robust exchange of ideas in these classes. The other thing that we know, although the court didn't attend as much to that, is that many of the, for instance, Latino students are clustered in particular majors and are not in some others. So that's another issue that they addressed. The other piece of evidence that was interesting is that they did a student survey on whether or not diversity had been achieved, whether people had the kind of interactions that they wanted, and a majority of students, and not just underrepresented students, said, no, we don't. So based on that, UT said, whatever our aggregate numbers, this is still not critical mass. Now, the lower courts deferred to the University of Texas. They said this was sufficient because we believe that you as higher education administrators deserve discretion and deference. The Supreme Court said this is too deferential. You've got to go back and really make the case. And what the justices said was, strict scrutiny cannot be strict in theory and fatal in fact, but it also cannot be strict in theory and feeble in fact. So, as I mentioned, there are a lot of unanswered questions. One of these on remand is whether this case is moot. And I find it very interesting that this is being resurrected on remand when it was largely kind of invisible on the way up. I'm not sanguine that the Fifth Circuit will say this is moot. But the other, I think, really interesting battle that's going on now at the Fifth Circuit Court of Appeals in Texas is whether this is going to go back to the district court on the factual record. Because what Abigail Fisher wants to say is whatever the University of Texas generated, the survey and the classroom evidence, is all it gets to produce. That's it. We're done. Enough. And we'll decide whether that meets this more searching version of strict scrutiny. And what the University of Texas wants to do is say, look, we thought the standard was different. Now the Supreme Court has made it tougher. Give us a chance to go back to the district court and produce more evidence about these issues. That fight is going on as we speak, whether this will be decided by the Fifth Circuit or whether it will go back to the district court. The impact of this case is significant. The Obama administration just sent out a letter about last Friday saying that this case doesn't change. You can still use race. We still use strict scrutiny. But the truth is, this case changes the burden of proof that colleges and universities will bear when they're public, when they use affirmative action. So what it means is you have to provide evidence, more evidence on whether race-neutral alternatives are an efficacious alternative. You have to provide more evidence on whether critical mass has been achieved. And not only do you have to provide that evidence at a particular moment, but you have to provide it over and over every year that you do admissions. So this is going to impose far more costs on universities to justify what they're doing. And remember, you can't say, wait a minute, nobody will sue, because the doors to the courthouse are wide open, right? If you only have to show you were exposed to a process you think is unfair. Now, I think that all of these questions are extremely interesting. I hope this group will have a lot to say with respect to them, because I believe, first of all, we need to watch this growing convergence between school desegregation cases at the elementary and secondary level and higher education cases. I think we can't be complacent. We can't drop the ball again on producing research. The court pretty much said that. So we have to figure out how to build a research infrastructure that will enable colleges and universities cost effectively, in a time, let's admit it, of declining budgets, to expend the resources. How can we use things like the National Survey of Student Engagement, which is administered broadly at many universities, to make the case about whether we still need diversity in admissions? What other instruments are out there that colleges and universities could use? I also want to say that we should also be watching the court next term, because there's a case coming up. As I mentioned, Michigan passed a popular referendum saying that you can't use race in admissions. That is being challenged on grounds as to whether or not that was appropriate, whether it locked in a restriction on race at the state level when most decisions are made at a local level, thereby chilling the ability of racial groups to organize and express their political preferences. We have some distinguished constitutional scholars like Cheryl Harris here. I'm not waiting for that to happen. I'm kind of pessimistic about that case coming out in a way that strikes down the Michigan referendum, but it certainly is one to watch. Now, as I mentioned, I have that unique opportunity to reflect at the end of the day when we hear from all these wonderful panelists. So I will come back to you with hopefully some interesting, creative, generative solutions and strategies for moving forward. But I just want to thank you for your commitment to these issues. They are tremendously important as we see growing class inequality at the same time that we see increasing diversity and we see a narrowing of commitment to higher education. This pathway to leadership is not what it used to be. We've already seen significant reversals. If you, like me, believe that public education has a special mission to serve people from all walks of life, I hope you will join me, along with the Chicano Studies Research Center, in making sure that we try to keep those portals of opportunity open. Thank you.
Thank you, Rachel. That was a wonderful framework with which to begin. And since we're at 1:30, I'm going to invite Carlos Haro to come up and serve as the moderator, and our speakers, Cheryl, Sylvia, and Robert, to come up to the panel. Those of you on the inner sanctum may find it easier to kind of turn your chairs and orient, or move them up if you want, whatever gives you the best viewing. So without further ado, Carlos will take us into the first panel.
Our first panel, Affirmative Action and Diversity in State Universities After Fisher. Professor Cheryl Harris. Incidentally, the bios for all of our presenters are in the program, so I won't read in totality each of the bios, but I will introduce them briefly. Professor Cheryl Harris is the Rosalind and Arthur Gilbert Foundation Chair in Civil Rights and Civil Liberties at UCLA School of Law. She teaches constitutional law, civil rights, employment discrimination, critical race theory, and race-conscious remedies. The interconnections between racial theory, civil rights practice, politics, and human rights have been important to her work. And she is the author of a groundbreaking scholarship in the field of critical race theory, including the influential article, Whiteness is Property, in the field of critical race theory. She's also author of several other pieces, several other articles that you can follow up with reading at a later time. She will be making the first presentation, and Professor Harris, if you wish to speak from the panel table or come up here.
Good afternoon, and thank you, Carlos, for the introduction, and thanks to all of you for being present, for your attention. I'm going low-tech today, no PowerPoint, and I'm assisted in the fact that Dean Rachel Moran just gave you an excellent primer on the Fisher case and an example of why she's been such an award-winning teacher before she became a dean. The title of my discussion, or my topic for today, is Reframing Affirmative Action in the Wake of Fisher Beyond Stricter Scrutiny. And I guess I would start just by saying that the framework that Dean Moran just laid out in terms of the details regarding the background of affirmative action in constitutional law is an important one. But what I also want to bring to the table today is thinking about the way in which affirmative action has been framed not only in law but in political and popular discourse, because I think there is a tremendous interaction between the way in which the court talks about affirmative action, the way we talk about it, the way the press talks about it, the way it's conceptualized. There's a kind of feedback loop. And in basically what I'm addressing today is what I think is a rather unhealthy feedback loop that has developed between popular political discourse and the way in which the issue is framed in law that needs to be interrupted if in fact the downward spiral that I think we're seeing with respect to robust enforcement and robust understandings of anti-discrimination law are to be restored. So notwithstanding the court's prior ruling on the constitutionality of affirmative action, the Michigan case, Grutter, the concept of affirmative action has been under really relentless assault for the past several decades, both in the courts, in the legislatures, and in the court of public opinion. And against this kind of hostile backdrop, the fact that the court did not take the opportunity in Fisher to outright overrule Grutter and to hold affirmative action to be unconstitutional, as many feared, was cause for relief. In fact, there was almost an audible sound of kind of whew, when the court decision came down, because as Dean Moran mentioned, people were holding their breath in anticipation of a much far worse outcome. And the fact that the University of Texas has an opportunity to defend its program to some extent means it has dodged the bullet and lived to fight another day. However, the terms upon which the court has now defined that fight have been implicitly redefined. A strict scrutiny, I contend, is now stricter scrutiny. And this has significant implications not only for how UT responds, but how the broader community, that is the educational community, the legal community, the political community, responds. Because accepting the existing terms really only increases the chances of defeat, not only for affirmative action in Fisher, but across the entire terrain of anti-discrimination law and policy. My point actually builds on Dean Moran's conception about the merger of desegregation law with the law of affirmative action in higher ed. And I want to actually add to that and suggest that ceding ground, which I think has been happening over the past several decades, by ceding ground on affirmative action. And what I mean by that is buying into the notion that the issue is to mend it, don't end it. Or in the case of O'Connor's kind of framework of after 25 years, it will no longer be needed. That is a kind of sunset provision. Or only using affirmative action if it is the absolute last resort and race-neutral alternatives cannot achieve any diversity. All these kinds of both, I would call them perhaps implementation concessions, as well as conceptual concessions, were a problem and a mistake because it did not, in fact, either adequately protect affirmative action, nor did it protect other forms of race-conscious remediation from being attacked. So now it's not only affirmative action that has been legally and politically subject to a kind of delegitimation campaign. It's also school desegregation at the K-12 level, as Dean Moran was talking about the parents involved in community schools from several years ago. The same kind of conceptual framework that was used to destabilize affirmative action was deployed against K-12 desegregation. And now, in this term, in addition to Fisher, the same framework has actually been applied to voting rights in the Shelby case. So my point is to say, and 2 terms ago was applied, although not technically in terms of the precise constitutional architecture, but the same conceptual idea was applied to anti-discrimination law under Title VII in a case called Ricci versus New Haven. You may remember this. This was the New Haven firefighters case. So my basic point is that the same kinds of moves that have been made to delegitimize affirmative action have now spread into the broader domain of anti-discrimination law and made it very, very difficult for any form of race-conscious mediation to meet the legal standard. So the challenge is not only to respond to the specific issue in Fisher, but to reframe the affirmative action debate in both political and legal discourse to move from a kind of tepid defense of so-called racial preferences as a tolerable deviation from otherwise fair and merit standards to a new discussion about social inclusion, the demands of equalizing opportunity, not just equal opportunity, and to remove the racial barriers to success. So I won't belabor sort of the specifics of what the court did, other than to say that this 7-1 decision actually did, in fact, open up the question of what the new standard now is. Texas, as Dee Moran pointed out, had adopted its policy after Hopwood, the top 10% plan, in part as a way to try to find a way around the barrier that Hopwood had put in place. And after Grutter basically took a second look and adopted the top 10% plan. This question of why adding race back in was necessary is a very interesting one. And it's also very interesting to think about the top 10% plan on its own, because there's two things that are important, and you all probably know about it. First of all, it was designed to get around a legal ban on using race, that is, to develop a race-neutral way to increase minority representation, but it in fact relies upon patterns of racial residential segregation. That is, the only way the top 10% plan delivers any racial diversity is because it sits on top of a fairly intense pattern of racial segregation in Texas. That means that if you take the top 10% of high school students, you're going to get diversity, but only because of racial segregation. So we have a very curious and contradictory way of calling this race neutral. It's actually race neutral, but it depends upon racial segregation. It also means it won't work everywhere. And it also means it doesn't work with respect to graduate admissions. It can't, because graduate admissions don't rely upon that kind of feeder system. The second thing is, one of the things that Texas found is, curiously, the top 10% plan somewhat hurts selectivity. So if you're interested in, as a university, as a top research institution as UT is, in selectivity, that is, in getting the best of the best, someone outside of the top 10% might actually have a higher test score or a stronger academic record, but under the system as Dee Moran described, the vast majority of the slots are going to people in the top 10%, but you yourself know, as people who have expertise in education, it isn't all about the class ranking, right? I mean, there are people that have tremendous academic strengths that are not going to be revealed through a class ranking. Secondly, the curious problem with the top 10% plan, and these were some of the issues that Texas was considering, is that it actually provides a disincentive to take difficult classes that may lower your GPA. So if you're actually creating a system which disincentivizes people from reaching for those really difficult courses because you don't want to suppress your GPA, you're actually working against yourself, right? The other thing is this question of diversity within diversity. Now, this was something that really confounded some of the justices on the court, and I just want to read you kind of where this went. Justice Alito, in particular, was confounded by this argument about diversity within diversity. Texas's lawyer said, look, one of the problems that we had with the top 10% plan is that if all of the Black and Latino students that are in the university are coming through the top 10% plan, what does that mean that they're doing? Virtually all of them are coming from de facto segregated schools. That is, virtually all of them are coming from these racially segregated high schools, most of which are low SES, effectively kind of reinforcing a stereotype about minority identity. That is, if diversity is about trying to break down the stereotype of associations between identity and a particular background, what the top 10% plan is actually doing is reinforcing that perception. That is, every Black and Latino student that you see is coming from a low SES background or non-English speaking background, or in some way that their identity is associated with a particular set of factors. So Texas was saying that what we actually are trying to do with adding race back in at the margins is allowing for the university to bring into play those people, those students who have a strong academic background, but who may be actually not coming from the same kind of background as everybody in the top 10% plan. Well, this was particularly confounding to Justice Alito. So the university's lawyer in oral argument says, although the top percentage plan certainly helps with minority admissions at large, the minorities who are admitted tend to come from segregated, racially identifiable schools. Justice Alito, well, I thought that was the whole purpose of affirmative action, was to help students who come from underprivileged backgrounds, but you make a very different argument that I don't think I've ever seen before. The top 10% plan admits lots of African Americans, lots, lots of Hispanics and a fair number of African Americans, but you say it's faulty because it doesn't admit enough African Americans and Hispanics who come from privileged backgrounds. And you specifically have the example of a child of successful professionals in Dallas. Now that's your argument. If you have an applicant whose parents are, let's say one of them is a partner in your law firm and another one is a corporate lawyer, and they have income that puts them in the top 1% of earners in the country, let's just think about the N in that set for a moment. What is the N on that, right? Children of two top lawyers, Black or Latino children who are children of two corporate partners. They deserve a leg up against, let's say, an Asian or a white applicant whose parents are absolutely average. The UT's attorney, no, Your Honor, and let me answer that question. First of all, the example that we're giving comes almost word for word from the Harvard plan that this court approved in Grutter and that Justice Powell held out in Bakke. Justice Alito, well, how can the answer to that question be no? Because being African American or being Hispanic is a plus factor. UT's lawyer, because, Your Honor, our point is that we want minorities from different backgrounds. We go out of our way to recruit minorities from all backgrounds. Justice Kennedy, so what you're saying that counts is race above all. Justice Kennedy, the reason that you're reaching out for the privileged is so that members of that race who are privileged can be representative, and that's race and race alone. So you can see from this dialogue how there's a kind of catch-22 that the university is finding itself in terms of trying to defend on the grounds of diversity, this notion of diversity within diversity. Now, they're not arguing that all of the slots should go to privileged people. The point is, though, is that if the idea is to break stereotype, what you've actually got is a contradiction inherent in the program that they are trying to navigate. So the point that I'm trying to bring here is that there were many reasons why UT went to this new system and added race back in at the margin. Dean Moran has usefully run through all of the numbers in the Texas admissions question and Abigail Fisher's sort of position in that. I would just add that the year that she applied, there were over 30,000 or about 30,000 applicants, about 6,700 accepted and enrolled. The vast majority, over 80% admitted through the top 10% plan, which meant that when you actually ran the numbers, about 216 Black and Latino students were admitted through a holistic review. That's out of all of those people. And in fact, Abigail Fisher's lawyer conceded that race played no role in the admission of 183 of those students. So now we're down to, I don't know, I do the math quickly. You can see that we're down to very, very few numbers, and she conceded that the impact of race on admissions was very much at the margins. Now note that that has its own catch-22. That is, if it's only operating at the margins, then is it necessary? Right? I mean, so, okay. So Abigail Fisher gets to make this claim even though she can't show that she would have been admitted but for the program. She can't, and she, in fact, because she has graduated, the question of mootness is on the table. So what is the remedy that she's seeking? And this is what Justice Sotomayor spent a great deal of time about at the beginning of the oral argument, trying to figure out. What is she suing for? She's not suing to get into school. What is the basis of her claim? She's not saying that she would have gotten in but for the program. She's suing for the return of her $100 application fee. And the injury that she's arguing is for that the use of the plan itself denied equal treatment. Now, this very expansive notion of standing that the court has adopted in the affirmative action cases, as well as, I might add, in the voting rights cases, in an earlier case called Shaw versus Reno, which challenged a minority voting district that had been crafted pursuant to the Voting Rights Act, the court allowed white plaintiffs to sue without any claim that the person that had been elected could not represent them. There was no basis for any claim. They did not raise a basis that said that the particular election of that out of that minority district caused them a specific harm. What they said was that somehow the use of race itself denied them equal treatment. The court has accepted that version of standing in the context of these kinds of cases. However, standing in contrast to that are the very restrictive rules on standing that it has adopted in other kinds of claims, including, for example, most famously coming out of Los Angeles, a case going back several decades where the police department used chokeholds on suspects, resulting in injury and death in several instances. The plaintiffs sued to stop the practice, alleging a constitutional violation, and the court said, well, you can't prove that there is an actual the potentiality of future injury by virtue of the use of this practice isn't sufficient for you now to be suing. Okay, so I just put that out there to say that the rules of standing have a particular racial skew as well. Now, the point that we're at in terms of what does narrow tailoring now require after Fisher. So on the one hand, the question that the court entertains is essentially what kind of deference is due to the university or to the institution. Where under a strict scrutiny standard, we understand that the university must meet a compelling interest standard, right? That's clear. Once the university says we're seeking to achieve diversity and make some evidence that that's what the program is designed to do, ostensibly it has met the standard. The real fight now comes in this narrow tailoring part, which in constitutional terms basically means you got to show that you really, really need it. Now, after Fisher, one might argue that it's not clear precisely what UT must do. On the one hand, the court said universities are different. There is a particular context that matters with respect to university. And it also said that it was pretty clear that the interest that Texas was asserting was not racial balancing, which it had declared to be impermissible in the K-12 instance when there was an attempt to defend a desegregation plan in K-12. But that's good, but then why now do I say that this is stricter scrutiny? It's because there's a real uncertainty regarding what it is UT must prove. The relevance of overall demographics is kind of lurking in all of this. So on the one hand, from Scalia's position, it's never relevant. That is, the disparity between the numbers of Latinos or Black students enrolled at UT and the actual demographics are not relevant. On the other hand, Sotomayor has intimated that it is relevant, not determinative. In other words, the fact that there is a gap does not mean that that ipso facto proves that there's a problem, but it is relevant. It's relevant, for example, to know that the population of Texas is 40% Latino. It's also relevant to know that the largest group of children in Texas who are below the poverty line are Latino. It's important to know all of that, she would argue, But we are going to have, I think, a fight about what the metric should be, and it's precisely because of the contradiction that Dean Moran indicated of what a critical mass constitutes. The harder you push towards specifying that number, the more you risk it being deemed a quota. The more you back away from specifying, the harder it is to sort of justify. So we have to think about what the metric should be. Tomiko Brown-Nagin, professor at Harvard Law, has argued that instead of state population and classroom and program numbers, that we should actually look to the proportion of underrepresented minorities, senior high school students in Texas who are eligible for admission. So in other words, she's saying rather than just sort of look at the broad demographics, we should actually get more granular, define it more precisely, actually look at those students who would be eligible to go to UT as defined by GPA and who are otherwise eligible for admission in an attempt to answer the court's questions about greater specificity. The other thing is this, sort of diversity within diversity argument. I think you can see where that's going. There was also a rather bizarre, sort of surreal interchange on the question of the typical way in which the conservative kind of assault on affirmative action has been to say that somehow it's harming Asians, right? Justice Alito picked up on this point and said, he says, well, in terms of diversity, how do you justify lumping together all Asian Americans? Do you think you have a critical mass of Filipino Americans, Cambodian Americans, etc.? Okay, so you can sort of see in that interchange a kind of skepticism that suggests we are very far removed from the notion of deference to the university on its educational mission. So one of the things that this sort of brings me to in my final sort of comments here is the challenge going forward. So under the narrow tailoring prong, I think what we can see in Fisher is a greater and greater pressure for more and more granular analysis of the facts and the characterizations of those facts. So what does necessary mean? Is it absolutely necessary? No other alternative necessary? Beyond a reasonable doubt necessary? We're kind of in that zone. But we're also in the zone of trying to sort of defend in a situation where the requisite proof requirements have gotten incrementally higher and higher. So what is the data that has to be produced? Now we're down into some fairly specific, hard kinds of research. What's interesting about that is that while it may be possible for UT to meet this difficult to quantify standard, if it does, what UT does may have less and less precedential value in terms of providing a roadmap to schools that are concerned about achieving the benefits of diversity. So the pressure of the test is to get more specific, right? But the problem with getting more specific is how do you then build on that in terms of building out to other institutions? Because the facts that you have to develop are so specific to that institution, that case, that situation, that year. How does that help then a school across the country in some other context to defend its program? Well, one could argue that at least you have a model to replicate. I'm not going to say it has no value, but it does have limited value in terms of precedent, meaning it's harder to cite the case as an example for why the program at your particular institution is okay. And this is actually ties back to my point at the beginning that much in the same way in the parents involved case, the court retained the shell of Brown versus Board of Education. It effectively undercut the possibility of effective remedies to actually achieve it. So the court gets to say, we didn't overrule Brown. Brown is still good law. It's just the question of now, what can you do constitutionally to actually achieve desegregation? As it continues to take remedy after remedy off the table, what you have is this situation where the shell of the right is present, but the actual ability to reinforce it is constrained. So Fisher retains Grutter, but effectively makes it more difficult for any school to meet its rearticulated test. Final thoughts. So here we are in this sort of legal morass to some extent. And the challenge is broader than this specific case. We're trying to learn how to litigate and to speak about race in a post-racial moment. And that, to me, is the great challenge. The court continues to frame not only affirmative action, but all racial remediation efforts, no matter what the context, in education, in employment, in voting, as racial preferences. They're all racial preferences. What's very distressing about this is that many liberals and progressives frame affirmative action in the same way as well. When Ward Connolly came to California, or I shouldn't say came to California, but when the campaign to enact Proposition 209 came to California, one of the major objectives, and he was fairly explicit about this, was to actually reframe affirmative action as a racial preference. He never refers to affirmative action as affirmative action. Never. And the campaign to do that has been so successful that if you read any article in any media, they pretty much all start with that frame. Now, why do I say that's problematic? Well, it's problematic because to say that it is a racial preference means that at heart, what you're doing is sort of accepting the idea of a racially neutral baseline against which race is being added in as a preference. The question I suppose to all of you who study this literature is, are we existing in an environment where we're at a racially neutral baseline with respect to the opportunities for communities across the state? I think the answer pretty clearly to anybody that looks at this is no. But the presumption inside of framing this as a racial preference is to say that basically we have a racially neutral baseline in which nobody is barred from sort of participating. We all agree that equal opportunity or denial of equal opportunity is a bad thing. But racism is not the primary cause for this inequality. And so what we have is, in an earlier moment, those who opposed race-conscious affirmative action included, for the most part, people who align themselves conservatively. Now what we have under a sort of racial preference framework is that those who oppose race-conscious affirmative action include people who politically self-identify as conservatives as well as liberals. And so people who hold very different political views on the proper role of regulation in the economy or on the environment have come to share a view about affirmative action that disaggregates it from the fundamental inequality in the system. And so the dominant consensus about affirmative action is that it's carving out an exception for an otherwise fair, neutral, merit-based process, and thus is justifiable only in exceptional circumstances. It has limited payoffs. It tends to grant benefits to those who need it the least. It requires us to do some things that are uncomfortable, like count by race, and rely on racial classifications as a proxy for ideas and viewpoints. So once you have that kind of general, broad consensus, it becomes very difficult to sort of move the debate. The prevailing understanding of racism assumes that it means to take race into account against an otherwise neutral baseline, and to the extent that there is any structural inequality, that it's largely a function of class. That is, that the real problem is poverty, not racism. So these views have taken on particular force with the election of Obama as the first African-American president, and he's presented as sort of the actual and symbolic evidence of this fact, right? And what's, of course, challenging is that very often he articulates this very viewpoint, the one that I just said. So now we have a quite difficult challenge that, let me put it to you this way. So many people, you may recall that during the oral argument on the Voting Rights Act case, that Scalia referred to it as a racial entitlement. I don't know if you all remember this. And there was actually, if you hear the tape, there was a little bit of an audible gasp when he said it. And it's like, what's really interesting is that while many people were aghast at his depiction of the Voting Rights Act's protections against exclusion from the franchise as an impermissible racial entitlement, in fact, he's relying on the same logical premises as those who frame affirmative action as a racial preference. Right? It's the same logic. And so part of what the challenge is to try to think about the ways in which we can and should and must disrupt this logic, not only for the purposes of the immediate and most important facts in Fisher, but for the future of anti-discrimination law more generally. Thank you.
We're going to have a question and answer period after all the panelists have presented. Unfortunately, Professor Devin Carbado was not able to join us today. He had a family situation to attend to, but we have Professor Robert Chao Romero, an associate professor of Chicano and Chicano Studies and Asian American Studies with us. He is a co-author of the policy brief and the research reports that you have. We also are going to have presenting with him a graduate student, Marcia Fuentes. Marcia is a doctoral candidate in higher education and organizational change in the Graduate School of Education and Information Studies. She co-authored the policy brief and the research report along with Professor Romero. So, Professor Romero, you're going to be speaking first and then
Yes.
Fuentes. Okay.
Good afternoon, everyone.
Good afternoon.
So our presentation this afternoon will look at Fisher through a few different lenses. My training is as a historian, as a lawyer, and as a Chicano Latino Studies professor and Asian American Studies professor. So I'm going to come at it with a little different vantage point. I think what makes our presentation probably unique, I would say, is that we will look at the policy ramifications for Latinos and higher education with regards to Fisher. That's kind of our unique bent. How does Fisher affect specifically Latinos in the United States? When we were preparing for this talk and the two reports that you have, we did a little searches online and we didn't find one article about the impact of Fisher upon Latinos. And so that's the void that we hope to fill here. I'm going to set things up by putting on my historian's hat and kind of fleshing out in a complementary way what Dean Moran talked about in terms of the history of affirmative action, kind of set that up, spend a little bit of time just refreshing our memories about the facts of Fisher, and then I will hand it over to Marcia to discuss the policy implications. So the United States Supreme Court ruling in Fisher comes as part of a really tumultuous 52-year official history of affirmative action. Affirmative action was a concept first coined by President John F. Kennedy as part of Executive Order 10925 in 1961. This executive order mandated that government contractors, quote, take affirmative action to ensure that applicants are employed and employees are treated during employment without regard to their race, creed, color, or national origin. This policy was not enforced in the context of higher education, however, until the passage of the Civil Rights Act of 1964. Title VI of this act called for the desegregation of higher education and threatened the loss of federal funds if institutions did not abide by the law. In an effort to subscribe to the federal mandate, institutions of higher education started the use of affirmative action policies and practices with respect to members of underrepresented ethnic and racial groups, including Latinos. It's important to note that as we teach affirmative action, like for example in the classroom, we highlight the fact that affirmative action did not start in 1961. Many racial preference policies benefited whites in the United States for, let's see, 1776 to, okay, with regards to, where people could live, what schools they could send their kids to, getting loans for houses, and many, many other things. And so it's really important from a historical perspective to note that affirmative action didn't start with JFK. The protestations against it started with JFK, but the concept itself existed for a couple of centuries before. The case of DeFunis v. Odegaard was the first U.S. Supreme Court case to challenge the consideration of race in university admissions. This was 1974. The case involved a lawsuit by white applicant Marco DeFunis, who alleged that he had been denied admission to the University of Washington Law School on account of his race, and in violation of the Equal Protection Clause of the 14th Amendment. Although the case was ultimately dismissed on procedural grounds, it was significant insofar as it was the first educational affirmative action case to reach the U.S. Supreme Court. I like to tell my students in my history of affirmative action class, so you had affirmative action for certain preferred racial groups, 1776 to, till for the present really, but for our purposes, into the 1960s. All of a sudden, in 1964, we say, okay, let's take race into account. And within 10 years, people are crying foul already, right? So you compare like 250 years versus 10 years. And it's like, that's the inequity, the inconsistency there. So DeFunis v. Odegaard comes about in 1974. Again, basically, within 10 years of the birth of affirmative action as we know it, and people are crying foul. It's unfair, it's reverse discrimination, all those arguments that you hear today. 4 years later, in Bakke, as Dean Moran stated, you had another big challenge here in California involving the medical school at UC Davis. And again, at issue in Bakke was whether UC Davis violated the Equal Protection Clause of the 14th Amendment through its implementation of separate admissions policies for white and minority medical school applicants. And it was Bakke which really established the constitutional parameters of race-based admissions and which governed affirmative action programs for basically a quarter century. So from 1978 until Grutter and Gratz in 2003, Bakke was sort of the law of the land. That's what people turned to. In his landmark opinion, Justice Powell asserted that diversity is a compelling interest which justifies the use of race in race-based affirmative action programs. Although race could be considered a plus factor in admissions decisions, it could never rise to the level of being decisive. Moreover, according to Powell, every candidate must receive individualized consideration of their application, and numerical quotas are always unconstitutional. So Bakke was around for about 20 years, undisturbed until the Hopwood v. Texas case, which was mentioned earlier. The central issue in Hopwood was whether diversity represented a compelling interest which justified the consideration of race in university admissions. Although Justice Powell clearly stated that diversity was a compelling interest in Bakke, his opinion was part of a plurality decision. So a majority of the court agreed with his final decision in the case, but did not sign on to his legal justification for the decision. So as a result, it was kind of up in the air. Like most schools felt, well, diversity is a compelling interest for purposes of the Constitution. But there was this sort of iffiness, if you will, like because of Justice Powell's opinion not being backed up, right, by 5 votes. And so the Fifth Circuit, they decided to say that, well, Powell's decision is not controlling because it wasn't backed up with 5 votes, so there's no compelling interest, no affirmative action in Texas. Right? Then, following the lead of Fifth Circuit, opponents of affirmative action filed similar constitutional challenges in federal appellate courts in Washington and Georgia. Smith versus the University of Washington Law School in 2000 involved another challenge to the diversity rationale. And this time it was brought by a white female student who was denied admission to the University of Washington Law School. So you'll hear the same similar states coming up, Washington, Texas, especially. Johnson v. Board of Regents of the University System of Georgia was spawned in 2001 by the rejection of 3 white female students to the University of Georgia. In Smith v. Washington, the Ninth Circuit upheld the use of diversity as a compelling interest according to Bakke, so they said Powell was right. In 2001, in Johnson v. Board of Regents, the 11th Circuit Court of Appeals, however, evaded this controversial question and instead based its ruling upon the grounds that the University of Georgia's race-conscious admissions policy was not narrowly tailored. So fast forward a couple of years, and the US Supreme Court intervenes into these muddy waters. In 2003, the Supreme Court intervened through the twin Michigan cases of Grutter v. Bollinger and Gratz v. Bollinger. Grutter and Gratz clarified the constitutional parameters of affirmative action, at least for the next decade. So as we discuss this case now, the Fisher case, things were pretty clear sailing for about 10 years, and then now we have this new big ruling. At issue in Grutter and Gratz was the constitutionality of the race-conscious admissions policies of the University of Michigan undergraduate program and law school. As in the several cases which preceded it, Grutter and Gratz involved the protestations of white applicants who were denied admissions to the university. So the central legal question posed in Grutter was whether, according to Justice Powell's famous opinion in Bakke, diversity in fact represented a compelling interest which justified the implementation of race-conscious admissions policies at public universities. That's sort of prong one of what they call the strict scrutiny. Is there a compelling interest to justify the explicit consideration of race? And that was what Grutter talked about. Gratz addressed the second prong of the strict scrutiny test, which is the law or policy, is it narrowly tailored? Does it trample upon the least amount of rights? Are there basically no alternatives to the policy or law in question? So Grutter and Gratz clarified that. In Grutter, the Supreme Court said, diversity is a compelling interest. Okay, subtle. And according to the court in Grutter, public universities have a compelling interest in obtaining the educational benefits which flow from a diverse student body. These benefits include the promotion of cross-racial understanding, the breaking down of stereotypes, and the preparation for a diverse global workforce. Whereas Grutter affirmed, I was about to insert a Chicano studies sort of comment, but I'll stop. Whereas Grutter affirmed Justice Powell's view that student body diversity is indeed a compelling interest, Gratz defined the contours of a constitutionally permissible affirmative action program. So what does it mean to be narrowly tailored? What does it mean for an admissions program to be narrowly tailored, as has been discussed previously? In further agreement with Bakke, the court ruled that race-conscious admissions programs are considered narrowly tailored if they provide individualized and holistic consideration of every applicant. Although race may be explicitly considered as one factor in admissions, racial considerations may not rise to the level of being a decisive factor, and quotas are always unconstitutional. Okay. And so Grutter and Gratz remain on the scene, largely uncontested until the Fisher case. So plaintiffs, as we've heard, claim that the race-conscious admissions policy at UT Austin violated their constitutional rights according to the Equal Protection Clause of the 14th Amendment. We've discussed some of the backgrounds of Fisher and Michalowicz, so I won't belabor those points. Plaintiffs Fisher and Michalowicz claim that the University of Texas plan violated their constitutional right to equal protection because of its explicit consideration of race. In order for its race-conscious admissions policy to be found constitutional, the University of Texas was required to prove that its policy was justified, again, by those two same things, the compelling interest and that it was narrowly tailored. Plaintiffs didn't challenge the first part, the compelling interest in diversity. Instead, they focused their claim upon the second prong of narrowly tailored. At first blush, again, like, this case is really clear. And we've talked about it already. I won't go into all the details, but it's like the University of Texas plan complied with Grutter and Gratz, like to the T, right? In fact, Grutter and Gratz applied so clearly that that this led Texas Solicitor General to famously comment, if the plaintiffs are right, then Grutter is wrong. So the case law was so clear that, again, it was said, if the plaintiffs are right, then Grutter is wrong. And so that the case went to the federal district court, and it didn't even go to trial. It just passed through summary judgment, went again to the circuit court, same thing, passed through summary judgment. So there was never like this detailed sort of look through a trial and you pull up experts and you do all this kind of stuff. That didn't happen at a trial level, and that became one of the main contentions once the case reached the U.S. Supreme Court. And so, as has been discussed already, in a 7-1 ruling, the Supreme Court vacated the decision of the lower court and ordered the case remanded to the Fifth Circuit Court of Appeals. Rather than address the substantive legal issues raised by the case, however, the court remanded the case on the grounds that the Fifth Circuit failed to properly apply the legal test of strict scrutiny. Specifically, the court held that the appeals court erred in deferring to the University of Texas's judgment that its admissions program was narrowly tailored and necessary for the promotion of student body diversity. Rather than deferring to the professional opinion of the university on this matter, according to the Supreme Court, the Fifth Circuit Court of Appeals should have conducted its own rigorous judicial review to determine whether or not the contested affirmative action program was in fact narrowly tailored. And I'll end with one quote and then I'll pass it on to Marcia. But here's a quote that I think summarizes this contention. It says, once the university has established that its goal of diversity is consistent with strict scrutiny, there must still be a further judicial determination that the admissions process meets strict scrutiny in its implementation. The university must prove that the means chosen by the university to attain diversity are narrowly tailored to that goal. On this point, the university receives no deference. But as the court said in Grutter, it remains at all times the university's obligation to demonstrate and the judiciary's obligation to determine that admissions processes ensure that each applicant is evaluated as an individual and not in a way that makes an applicant's race or ethnicity the defining feature of his or her application. And so the case, again, to summarize again, was sent back to the Fifth Circuit under these sort of muddy kind of procedural grounds. I won't go into more detail because we've discussed that a lot, but now I will turn it over to Marcia Fuentes, who will discuss what are the specific policy implications of Fisher for Latinos in higher education.
The state of confusion that we've been speaking of throughout the day today has led higher education into the state of really not knowing where to move from this ruling. And Larry White, the General Counsel at the University of Delaware, has quoted as saying, it's pretty clear what we have to do. What's not clear is how we have to do it and when we have to do it. Sorry for the formatting, got a little strange on the Mac. Anyways, so the what, which is what we do know, is, as the court stated, that strict scrutiny imposes on the university the ultimate burden of demonstrating, before turning to racial classifications, that available, workable, race-neutral alternatives do not suffice. So in other words, institutions wishing to use the practice of affirmative action in admissions need to demonstrate the need for race-conscious policies and practices over race-neutral alternatives to craft the level of student diversity necessary to meet their educational missions. Now, the checkbox that we can't quite check yet is, how do institutions demonstrate this need? Is it a matter of documentation and data? And if so, what documentation and data suffices? What documentation or data do institutions need to have available in order to demonstrate that race-neutral alternatives do not suffice? Additionally, when? When do institutions demonstrate their need? Do institutions need to undergo a period of trial and error before implementing race-conscious policies? Or can the quote-unquote serious consideration of race-neutral policies take place after using race as one factor in the admissions process? Or is it a trial and error phase of at least one race-neutral policy before moving on to a race-conscious policy. Now, as you can imagine, there's disagreement on this. Whereas proponents of affirmative action do not interpret the ruling to mean that a trial and error period must ensue before institutions can legally adopt race-conscious policies, opponents assert that public universities are liable to litigation if they did not first apply race-neutral policies to achieve their goals of diversity. And an additional unknown complicates things even further. Institutions do not know at this time how much deference the courts will allow them in determining the effectiveness of race-neutral policies and practices to achieve the goals that they need to meet their mission statements. So one of the ramifications of this state of uncertainty that we will likely see is that it will encourage a shift, an institutional shift, for campuses to use race-neutral policies in addition to or in place of race-conscious admissions policies. And so it is in this light that we give you the implications then for Latina and Latino students. So we know after Fisher that institutions, administrators, and policies makers have started to accrue data that will affirm their need for race-conscious practices, preparing for the next ruling and also preparing for possible litigation. And included in this process is an assessment of the impact that the adoption of race-neutral policies would have on the racial and ethnic composition of their student bodies. Now, thus far we know from social science research that the elimination of race-conscious practices, even when mitigated by race-neutral alternatives, as we know here in California, and increased programmatic efforts, disparately impacts Latinos and Latinos. And I will go through a few of these. So research indicates that for Latinas and Latinos, it decreases their application and enrollment rates at both the undergraduate and the graduate level, including professional schools. It also decreases their admission to selective campuses. Now you will see some empirical studies out there making the claim that, the perfect example is the state of California. They don't have affirmative action, they have comprehensive review, and their level of enrollment for students of color is the same across the UC system. That's true if you just look at the UC system on an aggregate. But if you take the time, as some research have done, to look at the impact across campuses at that level, you will see that the rate of admission and enrollment for Latinas and Latinos has particularly dropped at the most selective institutions within the UC system, speaking specifically to UC Berkeley and UCLA. So this effectively sorts Latinos and Latinas to less selective institutions, which we know by research has implications, as did Fisher, apparently, on what it means to go to a more selective institution. It also reduces their access to targeted scholarships and enrichment programs, which again, negatively impacts their ability to attend and then navigate the campuses to which they're admitted to. It negatively impacts their degree attainment. And importantly, it contributes to a negative campus climate experience. So some research has indicated that on campuses where affirmative action is banned, Latinos and other students of color face a particular level of stigmatization by their peers on campus, especially when there are renewed attacks on affirmative action, as we saw with Fisher v. Texas, and as we saw when Sanders' paper was published in the Daily Bruin, and the impact that that had on our students on this campus, and their level of feeling that they belonged and were wanted on campuses like these. As a whole, research shows that race-conscious policies are not supplanted by race-neutral alternatives. That is to say that race-neutral policies are unable to attain the same level of racial and ethnic diversity, including the level and representation of Latino and Latino students, as do race-conscious practices. And researchers have examined the race-neutral policies that we currently have on the table as higher education. These include comprehensive review, class-based policies, percent plans like those at Texas and Florida and here, and preferences to applicants from certain geographic locations. The presence of Latinos and Latinos and other historically excluded students of color drops when race-neutral initiatives take the place of race-conscious practice as the main vehicle for promoting racial and ethnic diversity. These findings relate to studies conducted using data from California, Texas, Florida, and Washington, as well as simulated projections. The court, however, has stated that race-neutral policies should be used if they work, quote unquote, about as well as race-conscious policies. Now the question, of course, remains, how will the courts define and apply this about as well measure? Is it by comparing the percent yield of student diversity, as Justice Kennedy seemed to allude in his opinion? So for example, if race-conscious policies yield an aggregate of 20% students of color, and race-neutral policies yield 15% students of color on a campus, is this considered about as well? And how is this efficiency defined? Particularly for Latinos and Latinos, are we looking at an aggregate of all students of color, or are we considering the representation of racial and ethnic groups separately? So here are some of our recommendations based on our report. We recommend that institutions of higher education and policymakers maximize the use of race-conscious policies and practices while they remain constitutional, as they clearly serve as an important tool for the admission and enrollment of Latinos and Latinos, and an important role in their matriculation with degree. They must also determine and document the extent to which existing race-conscious and race-neutral policies and practices affect their diversity needs on campus. They should also assess the viability of race-neutral strategies to meet the educational needs of diversity. And they should connect existing policies to specific institutional goals on diversity. So, in other words, why is it important for Latinos and Latinos to be represented equitably at institutions of higher education, and particularly at selective public institutions? We also contend that higher education institutions have the obligation to reassess admissions criteria, standards, and values. Measures of merit, we contend, do not conflict with goals of diversity. The current measures, such as SAT scores and gender bias along racial and ethnic lines, leading admissions officers to underestimate the potential of underrepresented students of color. And we really call, especially on selective institutions, especially those that are public, to use the power that they have to influence other institutions in the way that they use admissions criteria to set the bar for reviewing this tension that shouldn't exist between merit and diversity and how students are chosen for admission. And finally, I will close. Again, the slide got a little, I use a PC, so Mac doesn't translate as well. The educational achievement of Latinos and Latinos. Now, we know, of course, and this is something that can't be emphasized enough, that the life of opportunities afforded to Latinos and Latinos in the U.S. are shaped much earlier than the point at which they make college choice decisions, and affirmative action can impact them directly. And for this reason, we recommend strategies that include, but of course are not limited to what we have on one slide, K-12 outreach programs that are rooted in empirical research within high schools with a high representation of Latinos and Latinos. We also recommend cultivating college-going cultures, a practice that has been documented to have great efficiency within high schools, again, with a high representation of Latinos and Latinos. We also ask higher education and policymakers to buttress the financial aid available to Latinos and Latinos, given what we know that the role of finances and financial need in particular plays in the college choice, enrollment, and degree obtainment possibilities for Latinos and Latinos. And finally, as was addressed earlier by Dean Moran, we need to support relevant research on education. We're a little behind. So we really need to support, as was discussed earlier, investigating access and equities and examining the role of affirmative action to disrupt structures of oppression and exclusion. And educational professionals must support social science research that furthers an understanding of higher education access and equity for Latinos and other historically excluded populations, and that examines the current role played by affirmative action policies in disrupting these structures of oppression. So these were just, again, a few strategies that we offer. I'm sure that within the wealth of knowledge and expertise that's in the room, there are many others that we can speak to, but these are just a few. And this concludes our formal presentation. Thank you so much.
I'm reminded of one of the goals that we have for the Education Summit, and that is to prepare and train graduate students. And Marcia is a fine example of what that is about. And our graduate students that are here as part of a group in attendance. One of the first graduate students that I had working with me to plan the first Education Summit is now a professor at Cal State Long Beach. And she's going to be joining me in working on the next Education Summit that will focus in on education of undocumented students, the Dreamers. That'll be occurring next October. That'll be our Education Summit number 9. Now, we're continuing to move on this panel, and I think what Professor Hurtado is going to be doing is moving the ball forward with regards to some of the things that have been said earlier. Professor Sylvia Hurtado is going to speak on advancing access and diversity in institutions. Professor Hurtado is a professor in the Division of Higher Education and Organizational Change in the Graduate School of Education here at UCLA, and she is currently the director of the Higher Education Research Institute, which houses the Cooperative Institutional Research Program. And this is the longest running empirical study of higher education involving data collection on students and faculty in the United States. So Professor Hurtado.
To UCLA, and I would have to say that most of my work since I graduated from the program here at UCLA was focused on really improving the outcomes and the climates for underrepresented students in higher education. And I found myself involved in these cases. So I think when I'm going to talk to you today a little bit about how that we make that connection, though we also are facing some additional challenges today. So before I begin, I also wanted to say, so I'll relate to some of the work and research that we presented, and then some new research we have that gives even more insights into some of these issues. But I want to say a couple of things based on the previous speakers, which I'm really wonderful. It's a really wonderful opportunity. I'm glad this was organized because there's a lot of nuances that are buried within all this work and a lot of confusion, as Marcia was saying. But I think we need to really kind of keep our eye on the prize and really think, what is it we really need to accomplish and how can we get there? But let me just sort of say a couple of things about that are kind of background that's related to things that I knew, being involved directly in the Michigan case and providing the expert witness report and the data behind that, and also in the amicus briefs for Fisher, where I'll present a little bit of data we presented in that area. Is, first of all, voters did not decide that this was an important issue. This really comes from a calculated and concerted effort to close access to elite public institutions to underrepresented groups led by anti-affirmative action activists led by Ward Connolly. Let's get clear. It's a collective movement, okay? Second of all, these cases, as we knew in the Michigan case, similar groups searched for white applicants to be the face of these cases. We know, particularly in Michigan, they searched for 3 years to find someone who would represent the white plaintiff in this case. Third is the metric for race-neutral implementation and whether that's effective or not is really something that the other side is also watching. And I'll say basically is that their metric is if the numbers are too large, we need to stop it. Okay, so we're always going to be fighting that metric is that if the numbers are too large, obviously these institutions must be doing something wrong. UCLA must be doing something wrong in their race-neutral policy if they're actually getting more minorities admitted. Okay, so how can we win, right? How can we win in that? Because I think the only thing we have to decide is know that that's always going to be a question raised, but that shouldn't stop us from doing what we need to be doing. So let me start with some of the implications from both the Michigan case and also the Fisher case. We know from, if you want to go to the College Board Diversity Collaborative, that's a great website because they're actually providing information to inform campuses on what they ought to be doing. But there are several implications from these cases that haven't yet been mentioned, though others have. Is one, that we are now employing broader definitions of diversity. Okay? So we're kind of moving away from race, but broadening. The second is the access approach that is evident must be also connected to the pedagogy, the mission, and the initiatives in the institution. In other words, we are focusing a lot on the front end, but if the institution is not really embracing this as part of their mission and how they ought to be educating students, they're not going to be able to defend their policies at all. Okay? So all along I've told institutions, you need to embed whatever practice you have in everything that you do to show that this really is truly part of your educational mission. The third is the approach should be supported by evidence, and I think Marcia really talked a little bit about some of that, but including not just the evidence of is this policy, race-neutral policy, working or not working, and therefore we have to use an alternative method, but also whether it achieves the desired educational outcomes. I think one of the things we were happy about as social scientists and higher education researchers is we felt that Powell's initial idea really came to fruition in the data collected and provided in the Michigan cases that, by the way, came from the Higher Education Research Institute here, and also the Michigan specific information, but we could not understand whether that was true only at Michigan or institutions across the country if we had not been collecting data here at the Higher Education Research Institute to inform that decision and subsequent decisions, which I'll show you a little bit of new data. So really, essentially, the access approach of philosophy should be tied to educational goals and initiatives. So what do we mean by diversity today now as a result of these cases? One of the things that I do, by the way, I run an institute every summer for institutions to really talk about diversity research, why you do it, how important it is, and if you're challenged in a case, these are the kinds of information you need to have, so I do that. One is really now institutions are now adopting a multiple identity perspective. Diversity is now broadly defined. At the same time, I encourage campuses to continue to acknowledge the distinct populations and their needs. Those issues of equity do not go away. Okay? So while we know the educational benefits of diversity are great, there's a lot of criticism that we're neglecting the equity component. Well, I think it has to be both and approach. The second is there are different modes of learning about diversity. And sometimes when we talk about diversity, we're not really being clear about what we mean. And I think there's a broad range of initiatives, curricular initiatives, co-curricular initiatives, and also thinking about some of the frameworks that help us identify specific areas where we might connect them with some of the assessment processes. The third is, as this is the thing that I mentioned early, is distinguishing between diversity and equity. And I think one of the ways we really thought about diversity as being an educational benefit and how that comes to fruition under particular conditions is that you have to think that diversity is a resource and inequity is the problem. Many campuses say diversity is the problem. That's not the problem, okay? So a focus on both is necessary to achieve desired goals. So let me just talk a little bit about the educational benefits, because we're just saying, oh yeah, they accepted, courts accepted it, but given this is a large amount of work that has come out of the Higher Education Research Institute, I'll give you some of the most recent findings related to this. And these are really some of the democratic outcomes. And by the way, any kind of democratic outcomes are highly related to all forms of interaction across difference that we're finding in the data. Here I'm taking 3 different outcomes. There are constructs. One is social agency, that students' values in terms of how important it is to influence the social and political structure, help others in difficulty, etc. The pluralistic orientation is another construct we use and measure in our national surveys, all of our national surveys from freshman to 4-year and beyond. And basically it's the kinds of skills, we ask students about the kinds of skills for a diverse workplace and how well they're actually acquiring some of those skills, communicating difference, collaborating, openness to having their own views challenged, those kinds of things that are valued. And this came from an employer survey actually. And the third was political engagement, a number of things in terms of ways that students are getting politically involved these days. And there are at least several things that are pretty clear that are related to all of those things. This comes from about 19 different models looking across all of our national surveys to show students' habits of mind for lifelong learning are key, and these are kind of the academic skills that are important, that is in terms of evaluating sources of information, revising papers, those kinds of things that help students academically are related to these outcomes. But one that's very important is positive cross-race interaction, which is related to almost every single democratic outcome we could imagine. So the data are there, and glad that the court is no longer questioning that because we are actually showing that impact. But I encourage campuses to actually evaluate this so they understand how it works. There are other kinds of things that are very important, volunteer work, you imagine a whole range. These come from very large models, by the way. And an important one is whether or not the students believe the institution has respect for diverse beliefs. So those are important kinds of outcomes. So that's basically just giving you a quick update on some of the benefits, educational benefits of diversity. But the Fisher case in particular has been well articulated here previously, so there's not much more I would say other than we know the University of Texas has diversity on campus. So here's some results, and this was presented in the amicus brief. And they said, well, do we know if there's any difference between the proportion of underrepresented students and how often students feel they're discriminated? And I said, yes, we do have that data. And one of the things that you'll find is that nationally, in terms of reporting an incident of discrimination on campus, it's very low. I think the percentage is about 11% of students nationally will say that there is some incident of discrimination. Now, we also know that the incidence of harassment, threats, more violent incidents are punishable, and also that they are more likely to be reported. But what we're finding is that we see underrepresented groups more likely to report them, obviously, in institutions where there is low diversity. So we're seeing some effects of this racial isolation, that there is more discrimination, even though these numbers are low. Now, the numbers are higher when you start looking at more subtle forms that are happening on campus. And we actually have measures of everything from comments to emails to really trying to understand what dimensions, how subtle some of these things are and how more overt that are punishable. A lot of them are not punishable because they happen between individuals on the campus, but they need to be monitored. Okay, so here's one of the types of discrimination. It's called feelings of exclusion on campus. They felt excluded in some way by some event, by particular groups, etc. Again, we find that underrepresented students are more likely to feel excluded on those campuses where the percentage of underrepresented students is lower. It gets a little better at the midpoint, but even those that have over 36% students of color on campus, we still see some level of exclusion. So stereotyping, discrimination, you're not going to see it eliminated completely even in the most diverse campuses. In fact, you could even have a little more conflict if those students don't know how to interact with each other. But here we're seeing that, and my concern is that even Latinos, now the 36% or more, Latinos are quickly becoming the largest minority group on even four-year campuses. And so we're seeing that even then we see not that much of a decline. So there's something happening when students start to become more of a majority. You also see some more incidents that can occur. Okay, so I encourage institutions to really look at their climate because it helps to show the racial isolation issues and how that's going on. And we have to accept the fact that students are educated in racialized contexts. For us to ignore that fact is really not a good thing, especially when, even in the case where you have a lot of diversity, you need to understand how to help students develop the learning that happens across groups. So one of the things that happens obviously is in the classroom, and I want to just turn to a few other kind of structural issues, diversity of the faculty and diversity in the curriculum, because that really is where the rubber meets the road in terms of institutional commitment. And so what we see is this construct is called academic validation, how often students feel that their contributions are valued in class, that they got good feedback from faculty, that anyway, they felt that they were academically validated. They didn't feel excluded or felt that they were diminished in some way. And it's higher the more minority faculty you have on campus. So students feel more academically validated in this. The other thing is there are differences between white and underrepresented faculty in terms of the goals for undergraduate education. This comes from our national faculty survey. And students, faculty are more likely to have the goals when they're coming into and teaching these general education courses, enhancing students' knowledge and appreciation for different racial ethnic groups. There are a little bit, though we have to go a long way in advancing this area, engaging students in civil discourse along controversial issues, and we have some initiatives on that. And then teaching students tolerance, respect for diverse beliefs. So a little bit better, not as much of a difference, but there is a difference. So the diverse faculty is very important. The final thing really gets at some course content issues, and so I think these are some issues that are very important in terms of really what students are learning on campuses, and really also suggest that the campus really believes this is important. If it's part of your educational mission, you're not just going to have diverse students, but you're going to enable them to learn more about each other in the process. So we know the more courses that students take, the more academically validated they feel in terms of courses that address materials and readings about privilege and oppression, readings on race, ethnicity, and readings about gender issues. So we can't have them unconnected, they have to be connected together. I think I want to say just a couple of things, and then certainly I think what I presented really gives you a sense of there's a range of data that's available to campuses to really show what they're doing and how students are impacted. And I think we need to continue to monitor that because it's going to be helpful, not just in improving our educational environments, which I thought all along that was our thing, that was what we're supposed to be doing, but also in terms of defense and in terms of some of the cases. And this notion of racial isolation then makes it very important to continue to monitor the climate on campus, particularly as numbers go down or go up. We want to understand how that's changing. As I said, the phenomena of underrepresentation continues, and reducing racial isolation is a recognized goal. At least we have Supreme Court justices talking about this. To me, as a social scientist, that's a huge leap to have a conversation, though of course, have Scalia saying, what's a critical mass? Is that a critical cloud? We can't define it, etc. But when you couch it in terms of racial isolation, people seem to get it. They understand a little bit more. And it moves us away from really talking about a number. And I think the social scientists were very concerned when everybody said, well, what is a number? What's a threshold point? And we said, we won't go there. And in fact, the numbers that I showed are really somewhat common to studies that have been done on women in corporation, that they were less stereotyped when the numbers went beyond 35%. But as soon as we offer a percentage, we're going to get slammed. So we have stepped away and said there's different ways we can look at this metric of racial isolation. We should try to monitor it and improve it. The other part is really thinking about the practices that improve the climate for, particularly for Latinos, African Americans, and Native Americans. And I think that really, I think that's kind of been neglected, but those race-specific and race-targeted practices have also come under fire. And so we need to really think about how we're going to support those programs. And one of it is to reduce racial isolation and to make sure that those students are having a successful educational experience. And the other, of course, is research on the climate, and particularly under race-neutral policies. And so that is going to be very important, because sort of say, well, we can use this policy, but guess what? We're actually creating more problems on campus in terms of not just racial isolation, but we're actually having a recurrence of racial incidents. So I thought it was fitting to sort of say, this post-racial society, guess what? It's more complex, but we still have the same problems. You can eliminate affirmative action. They said, get rid of affirmative action, therefore students wouldn't be stereotyped any longer. Guess what? We don't have affirmative action, and they're still getting stereotyped. They're still getting discriminated against. They're still getting attacked. And we have to do something as an educational institution to change that around. Employers want us to get diversity right. They're tired of doing those diversity trainings because they are having, and they have basically said, do it, because we really would prefer someone who can handle a diverse workplace. And when you start talking a little bit to a white student about that, they finally get it. Oh, I got to have these skills. Yes, those skills are very important. The other point is faculty diversity and diversity in curriculum. Now, we end our Harvard Education Review article that came from the case, basically the 4-year data, though we actually looked at students 9 years after college entry to find out what happened with them, is that yes, faculty diversity and diversity curriculum are important, but it's not enough. You also need to have the diverse peers. That students cannot learn about diversity in an abstract way. And when you have peers in the classroom, it brings the points home. So those are the key pieces, and they're interconnected. And while we want to focus on one, even as we're struggling to increase the numbers and find ways to admit students, we have to pay attention to how they're educated once they arrive. And so I think I'll end there, and I think we have plenty to talk about.
Hear you. Please indicate if you want to address the question to one of the presenters. Any volunteers to begin the process? Someone from the audience wants a question? We have answered all of your questions. The program has ended. Oh, somebody must want to ask a question of one of the presenters or of the entire group. There is a question.
Thank you. I have a question for Ms. Hurtado. I'd like to know about which are the strategies that you believe will be helpful to this process. I believe that it's a matter of using different strategies, because I think we have the elements and we're a very rich community intellectually and culturally, and I think we can achieve that. So I would like to know what are some of the strategies.
Wow. I don't know if I have all the answers. I mean, I don't think I have all the answers, but I think institutions are finding their way. And when you talk about strategies, there are certainly, I think one is to think about admission strategy, obviously you're thinking about, and the other strategies are about understanding how you support your initiatives on campus. And so I'm not sure whether you're referring to the admission strategies or the strategy of really integrating what your philosophy is in terms of admissions with the programming and initiatives. Can you clarify?
I'm referring to the strategies that you will be using to improve the elements for the participants, for the students in the
Oh,
yes.
Okay. Strategies for improving. I think in my talk, what I tried to do was tie the notion that that whatever process you end up adopting, that you really also have to tie it to educational programming and practice. And one of the things that we obviously know, the more underrepresented students feel marginalized in these communities. We can do some research to document that, to understand how to better improve that. And lots of campuses have been employing climate assessments, not simply because they think this will, they have an idea on how to improve. Actually, a lot of them don't have an idea because they don't have a handle on the problem. And so I think doing some of these research at your institution can be very helpful to not just, defend whatever practice you have, but also to improve the situation for students. For example, more recently I've been working with campuses because they have had incidents. They're recurring again, and they're trying to figure out what to do better. And for some of these, it's real information that, how marginalized students feel. They think everyone is, kumbaya, getting along, all that kind of stuff, that things are going really well, and it's not. We don't have I think that a lot of them don't have a full understanding what it means to be underrepresented, and also what it means to be in a really diverse environment where you are excluded, which is distinct. So we're seeing both in diverse institutions and those that are least diverse, these issues, new issues arise about what it means to be truly integrated, and for the educational benefits to arise, how to achieve them. So I think the main condition for actually achieving educational benefits diversity, because we've just shown the relationship between positive interaction and a whole range of outcomes, is really the mechanisms by which those occur, which is another area that we're doing new research in education about. I think one of the strategy that I think is very helpful, and UCLA started along those lines, is really having these intergroup dialogue programs where you actually get a chance to really help guide students through a process, and they may have had a long-standing history of conflict. And so you're recognizing socialization, you're recognizing identity development, and then you're also recognizing that you have to help students develop communication tools. And then that necessarily has to happen in the classroom as well. So I think, to me, that's a very productive strategy.
Another question? I have a question. Oh, there it is. There's a question right there.
Thank you to the panelists. My question was around gender, and I guess I'm wondering how you all see Abigail Fisher's gender complicating the conversation a little bit more, even in result of what we know from the data, who benefited from affirmative action, and the fact that the selection here is a white woman. I was just wondering if any of you have comments on that.
It's a fascinating question, and I guess I would say at the strategic level, and I think this is something that Sylvia was alluding to, the search for the plaintiffs in Grutter and Gratz was very specific. They were looking for a white woman. They weren't just looking for a white plaintiff. They were looking for a white woman. And the reason had to do with essentially working the kind of, I guess I would say, ambivalence around and conception around affirmative action. Understanding that affirmative action as originally conceived was born out of, to some degree, the struggle over racial justice, but it had always, and actually from its conception, had a notion about its application to and benefits on the grounds of gender. But now, as we have moved, as Robert was talking, several decades out, the question of who is a beneficiary of affirmative action in public and popular discourse has basically been reduced to race. Meaning, if we were to ask in a room who has been the beneficiary of affirmative action, the only people that raise their hand are people of color, not white women. And nevertheless, they have been have received arguably the most benefits. Yes. So one of the problems that we face is actually shifting that discourse and being able to reclaim being a beneficiary of affirmative action not as a badge of shame, but rather as the benefit of a social inclusion policy that was not in fact a racial preference or a gender preference, but was rather a program designed to eliminate some disadvantage and barriers. And I guess I would say the final thing is the interesting research that came out of Washington State is in looking at the states where there have been propositions to eliminate affirmative action. One of the questions was how to essentially craft a winning coalition to defeat those initiatives. And one of the questions was, how do we sort of frame the arguments in terms that appeal to white women? The notion was that somehow just simply saying that white women were the beneficiaries, or that your daughters or your sisters could benefit from affirmative action, actually did not prove to be terribly successful in Washington State. There's a law professor by the name of Sumi Cho who did some interesting research on what happened in Washington State. And what she found is that rather than white women identifying as white women with either their daughters or their sisters or as themselves with affirmative action, they rather identified in terms of the white family interest and saw that as a line against it. So the point I guess I would say is that gender absolutely complicates this question and is one that I think is important to understand, because in terms of anti-affirmative action politics, they have mobilized gender in a particular way, right? Yeah, and class, by the way, that's a whole nother.
Here's a question.
Hi, I am a college prep manager for a nonprofit in downtown LA, and we service youth from South Central and East LA. My interest is there's a lot of research and a lot of articles coming out saying that our minority youth, first generation youth, are undermatched when it comes to elite institutions or college apps, and middle class and upper class kids are overmatched. So I was wondering, any of you, where is that disconnect? Is it that we are not promoting elite institutions to our youth and therefore they're not applying? Is it that the ones that are applying are not eligible? Are the college admissions afraid of letting these kids in and getting sued for affirmative action? Where's the disconnect? Because as a college counselor, I see many students that are qualified for a top university, and when top universities are claiming that there's just not, these students are not applying, it's a confusing aspect.
I think there's a lot of disconnect. There's a recent report that Tony Cannaveri just came out with, and basically talks about the racial stratification of higher education institutions and how it has increased, and the underrepresentation of Blacks, Latinos, and Native Americans, particularly in elite institutions. And so, gosh, I'm just finishing finishing another book on Mexican Americans, and it just starts, it's everywhere down the line, from teachers telling students that they won't write letters for these elite institutions, except for some of the publics. They require letters of recommendation, and from the counselor, and also from the teachers. And so these are mostly private institutions. I don't know which publics are doing that now. We don't do it at UC. We have just too many applicants. But that's a big place where the lack of enthusiasm within schools and the low teacher expectations play a huge role. The second is really the peers, and I think that's another thing. If you're in an environment where all of your peers are going to college, you're going to go to college, and you hear them talking about various things. So there's a lot of components that are related to this. And well, in particular, Latino families are encouraging. They want their students, they want their kids to have good lives and to get an education, etc. They don't have the social networks and even what we call sort of the access capital to really think about it. They've just moved into the middle class The question is, where can we afford to go, right? So I think there's a whole class, middle class issue, particularly in Texas too, that actually had an interesting effect on Latinos who were just making it into the middle class and didn't go into the top 10%, which is a different argument than what was argued among the justices. But that's a whole nother range of students who are making it, but then are choosing other, even though they're qualified to go to these other institutions, are choosing to go elsewhere. And part of it is also really concern about finances, which is huge for not only low-income students, but middle-income students as well. So it's a number of dynamics, and as a counselor, if you can help in any way, because for the longest time, counselors were part of the problem as well, is saying you're not qualified, or you better take another set, or apply to this particular institution, they accept everyone, kind of thing. So students are still being channeled into the institutions that are that don't have as many resources, and so we're seeing this this effect. In fact, previous years we may have had even more progress than we see today, and we are seeing even more racial stratification among institutions. So anything you can do as a counselor would be very helpful.
I just had one addition. I don't know if any of you saw a recent, I believe it was the Wall Street Journal or New York Times article where they were interviewed, or it was about the story of a young African-American student at Berkeley who was basically drowning, as they described it. So one of the things I wanted to mention is sort of the role of popular discourse in the media in reinforcing the dynamics that Sylvia was just mentioning. So in an environment where the entire discussion regarding affirmative action is A, that it's a racial preference, and B, that it's actually harming its intended beneficiaries because it's putting them in places where they cannot compete. You're definitely facing a number of challenges in terms of encouraging students to reach. Now, what's very interesting about this argument that people need to be put where they belong, which is essentially what it boils down to, is that in no other area of education do we counsel students to only reach for what they feel comfortable reaching for, right? If you think about even the dynamic of people deciding where they live, part of it is driven by where is the best school district, and the idea is you're putting your kid in a school where they're going to have to reach. And what all the education research tends to show, at least as me as a lawyer who's fairly ignorant about this, and correct me if I'm wrong, but it suggests that if you actually want to see achievement, you actually have to push a kid, put them in an environment where they're going to be reaching. The higher expectations actually produces higher results. But nevertheless, the overarching kind of framework regarding affirmative action is except for you people, because we need to put you where you can fit best.
Just add a couple of personal notes. I was one of the students that was told, oh, you can't come to UCLA or even to the UC system. That's me. I think campus climate is probably something to do with it too. I'll just tell a story. About 2 months ago, I had invited a group of urban students, mostly Latino students from Santa Ana, to come to visit UCLA, come visit my office and stuff like that. And so we walked to the elevators at Bunch Hall, and I just pressed the button a couple times, just waiting. And then there was a professor there, I won't say who it was, right? Who started who told me, she didn't know I was a professor. And she said, oh, you only have to press the button once for it to work. I'm a tenured professor, I have a JD, a PhD, I'm a lawyer, all these kind of things. We get into the elevator, and then large group of Latino students come in, and we walk in, and the elevator is like some of the buttons for the upper levels are pressed, and we didn't know whether they pressed ahead of time or did one of the students press it. That professor looked at the students and blamed them and said, did you do that? And I got so mad, and I just kind of told her off, and I told her, I'm a tenured professor here, and so on and so forth, and this is their first time visiting a university. You're poisoning the well, right? Destroying their experience. And she just, got to her floor and walked off, and but that really impacted me. I mean, for a couple of days, I debated, should I do anything like that? And that was, if I experienced that, I'm a professor, That's not to mention, I can tell you a lot of racial profiling stories, but that's a different discussion. But then how much more of these students, the climate has a big deal to do with it.
Mm-hmm. All right. I think there are many stories among this group that are similar. I won't go back to the 60s and relate my experiences here at UCLA. One more question.
Having been a victim of some of that in the 70s, I'm just curious if now there's some kind of forum for students to go to speak to someone at administration when we are discriminated on campus. Because, you know, you can make it into these schools, but attainment and achievement is another issue. You know, when will we complete if we have all these barriers, if we have instructors that are not supportive of us in this environment? I'm wondering if now, because I've been out of school a little while, but I was wondering if there's a forum for students that's, you know, since I am at UCLA right now, can you tell me, is there a location where students can go to kind of express their concerns about a teacher who is reducing the expectation or making statements that are not supportive to allow us to complete our curriculum?
I would defer the question. I'm not really sure the answer to that.
Probably Anita.
Oh, yes. Yes.
Probably have a question.
Well, I will answer. I think that you can go.
Get your mic.
Use the mic. Oh, right. Sorry. Thank you. It's a great question. I think we pride ourselves in giving students and all members of the community an opportunity to express their concerns regardless of what their status in the institution is, whether a staff, a student, or a faculty member. As far as student is concerned, I think we feel very strongly that there has to be a whole variety of avenues for students to enter the system and express their concerns. There are a whole number of them. You can talk to the chairman of a particular department. You can talk to the dean of students office. You can talk to my office in student affairs. Depending what your activity relationships might be, there are a variety of other professionals that are available to you, and we will work with you to engage the particular faculty member, the particular department, to try to find a resolution and to educate the different participants.
I'm going to close this part of the session. As I look around, I see people that want to get up and walk around, exercise a little bit. All right, we will take a 5-minute break, 5 minutes, and then we'll begin with panel number 2. Thank you.